I'm Joanne Law, Director of Studies for Mediation Institute and co-founder of Interact Support. I'm on a mission to prevent violence by training and supporting dispute resolution practitioners. Mediation Musings is a series of conversations with mediators and for mediators. So if you're interested in dispute resolution, follow the channel. We're intending to update new recordings each week. Enjoy. Today I'm talking with Veerash Srikison, who's a mediator and a lawyer based in Johannesburg. So thank you for getting up early to have a chat with us.
Only my pleasure. Thank you very much for inviting me, Joanne.
No, not at all. So, look, I really like to, as you know, I'm based in Australia and our listeners are mainly in Australia, although we do have some people checking in from all around the place. So it's really good to get a bit of a perspective on, what's happening with dispute resolution in other parts of the world. So thank you so much for agreeing to have a chat. So firstly, I wonder if you could tell me a little bit more about the sort of people you work with. What type of mediation do you do?
So I work in various services where I get to use my mediation skills. Starting off with my family and divorce mediation practice that I have their practice. Where I work with parents and them having to draft their parenting plans and working with their children. It's new. Mediation is not very new to South Africa because of our cultural background of the indigenous people, but it's not either firmly entrenched in our procedural law. So most of my mediation services come through the private sector. I also work with organizations where they have workplace disputes. So if they have employees that just aren't getting along, or there's just grievances between employer and employee, then I go in there using my mediation skills to help them resolve or get down to the bottom of why there's a dispute within the workplace. Then there's, I chair disciplinary hearings. So we do have matters where, again, labor issues, or we have issues at the universities where we've got students and management having problems resolving what their differences are in terms of how they'd want university curriculum to be conducted. So I also engaged on that level using my mediation skills to get everybody talking to understand where can we find a middle ground and what everybody's concerns are. Then having had all of this knowledge and expertise and experience, I've been commissioned to do training in mediation as well as negotiation. So I do train delegates, usually postgraduate professionals, well, anyone from any background in mediation and negotiation. So under the auspices of Fair Practice, which is my organization, I do a whole range of services that incorporate my mediation skills.
Oh, excellent. So that you've got a really good breadth of understanding of the, both, I suppose, the industry, but also the types of disputes that people find themselves in. So,
and I think the part about being a mediator is that no two disputes are the same. So you don't have a generic approach to any dispute. So that's what mediation prepares you for, is just be able to deal with people as they come to you.
Yeah. Look, I think that's a really critical point. The process underpins, but the individuals that you've got in front of you determine what's going to happen in that specific mediation, doesn't it? It's not.
It is. Yeah. And I'm sure many mediators in Australia as well will say the same thing, is they don't ever walk into a room already knowing who they're going to meet or what the outcome is going to be or what they're going to say. It's really you going in there to listen, to actively listen and understand what the dispute is, because you are the only person who has that third perspective that sees both sides of the story. And it's more of a focused skill that you have to use to bring the parties or the people in front of you to see both sides of the story.
Yeah. Look, it's very, very true. Actually, it just as you were saying that, I just had an image of kind of playing cards, and as a mediator, we get to go and have a look at both cards at both ends.
Yeah. But then it becomes difficult because you don't know how to actually inform them and actually don't make that move because it puts you in a bit of a bind.
Exactly. So and that's the challenge, isn't it? That we've always got that how do we manage confidentiality and yet encourage the sharing of information.
And I think that's one of them when I train. It's one of the most difficult skills I find with my delegates who come in for training to manage, because they're so ingrained. And most of them are a legal professional. They're so ingrained in taking a side that they forget that they have to not get involved. This is not personal. And the second part is it's not about you. So don't go in there telling someone what you think should be the outcome is.
Yes.
And it's difficult to get I think that's where they struggle, saying, I'm not ready to go out in the real world and mediate because I think I'm going to get personally involved. And the focus of the skills training is take yourself out of the picture.
Yes. Yeah, it's really, really critical, and that's relevant for anyone, anywhere at all that's seeking to be a mediator. It's not about us. It's not about our opinion, and we really do need to step out of that picture and remember that we're facilitating. It's not, we don't have to live with the outcome.
No.
And
I think that's a good point, Joanne, because even when people are sitting in front of you, they always turn to you, and I'm talking to people who now want to train to become mediators, people who have just started with mediating. Your clients or the people sitting in front of you will say, well, what do you think? And it's just one of those red herrings that you might just accidentally answer, which is something there's a fundamental rule for mediators: never answer that question from your perspective. And to all the new mediators coming out there and those who want to go into it, it's just always remember that golden rule.
Yeah, that's wonderful advice. It's really, really important. So I'm just wondering, because in Australia, I'm a family dispute resolution practitioner, so I do family law mediation, but we've got legislation around that in our Family Law Act. What's the situation for you there in South Africa?
Currently, we don't have mediation that's firmly entrenched in our procedural law, but we do have various legislation that provides for compulsory mediation, that's our Children's Act. So that's where my main focus is when I'm dealing with family and divorce mediation, is to remind parties that mandatory mediation does exist in our Children's Act. And we have a mediation in legislation around corporate company law, corporate labor law especially. We have the CCMA, the Conciliation, Mediation, Arbitration Commission, where our labor disputes first go into a CCMA process. So using alternate dispute resolution or ADR, appropriate dispute resolution methods, the dispute is first attempted in this amicable manner before it actually reaches our labor courts or labor courts of appeal. So it is there. However, because of this deeply entrenched belief that a better outcome will come from being in a court, the public is reluctant to use it because they feel it's such a soft approach. It's not the traditional winner-takes-all approach. And our legal practitioners are not advocating for it to be the primary start to dispute resolution. However, our courts are now becoming more aware of it. We've got this pilot project that started in December 2014, where it was court annex mediation was rolled out in our magistrates' courts in various provinces, and it's gaining momentum. It just needs more buy-in from the public and legal practitioners.
Yeah. Look, it's a similar sort of thing here. Probably a little bit further on, but and I think it's in a way, it's a function of conflict. People want to be able to just hand it over to someone else to sort it out. And
It is.
as a mediator, we're saying, oh, you get to make your own decisions and it's really great. And they're saying, well, I don't want to.
Yeah, and I think it comes down to mediators understanding that people don't want to take responsibility for the outcome. If it doesn't go, if the outcome doesn't seem favorable in a year or two, they want to find someone to blame for it. Yeah. They don't want to take responsibility for actually implementing it and making it work. Yeah. So again, another tip to up and coming mediators is just understand that it's as much as you might want to tell them, listen, guys, make a decision and follow through on it. Sometimes people are afraid of that decision that they make.
Yeah. Yeah, and look, the reality, particularly in family mediation, it's often going to need tweaking anyway as the children grow and things change. So, often what I'm able to say to people is, well, this is going to, give it a go for now and see how it works and see how it works for your family and then, perhaps do a review and see if there's any changes needed and that can sometimes take away a little bit of that fear.
It does. And in our Children's Act as well, it provides specific clauses, specific sections mandating mediation as for drafting this parenting plan as an evolving document. It's not something that's stagnant. It's not something that's written in cast in stone. And unfortunately, because of the litigious process, the parties don't know that you can go and make changes, like you said, the review clause. What we're seeing here being drafted, there is no review clause. So they don't think that we can go back and look at the developmental stage of our child, the maturity of our child, the age of our child, which our Children's Act says, look at these factors when you're making decisions for your children. But somehow our Children's Act just gets relegated to a sideline because it's a new legislation. Well, it came about in 2005, but it's still being debated. The contents of it is still being debated. There's, even our Constitution makes way for children to be participant in all matters related to them. It's drawn out quite well in our Children's Act, but it's just not getting the attention it needs to get. And it's because we've got practitioners who are so ingrained in a generic approach that they don't want to inform parties that bring your children in, they can provide some input. And also, we've got quite a landmark case. It's the Brownlee judgment, where the acting judge put a cost order in place against the attorneys for not informing the parties that they need to go to mediation to reduce costs and time spent.
Wow.
So if everybody wants to, so if everyone wants to have a look at that Brownlee judgment, it's NB versus NB or BROWNLEE, that judgment, you will see that it's quite revolutionary in terms of how courts are now approaching divorce disputes and mediation. So it's started quite a snowball effect in terms of our courts.
Yeah. Oh, that's great, because that really does send a strong signal to to lawyers that you have to give a fair go to these alternatives, not just push people straight through to court.
And the courts have also issued practice directives. So we have one in one of our cities, Belleville, where the magistrates gave it a practice directive saying, take your divorce matter to mediation first. So take your matter to mediation first before you come to litigate it. However, the backfire on that is, from what I see in my practice, is practitioners using mediation as a sort of a tick box. So they will send their clients to mediation, say, look, you just need to attend one session so we can tell the court you attempted it. It's voluntary anyway. And then they don't come back. And however, what happens in mediation, and if to the listeners there, if you're a very good mediator, the clients actually do want to come back. and they see the benefits of it.
Yeah.
It's just the practitioners talk them out of it. And that then just becomes a battle between mediators and practitioners saying, but we narrow the issues for you to go and get agreement on. And they don't seem to see it that, they just see it as you're taking work away from us. Yeah. So it, there's just always that underlying mediators are the enemy to dispute, which we're not. And I also come from a legal background, so I see again both sides of the story and all sides of the story. And I find that with my clients, when they sit in their first mediation session, the questions the mediator asks, some of them have never been asked by their own attorneys.
No, that's the sad bit, isn't it? That the attorneys really aren't doing a good review of the case and the situation in some cases, and I'm not quite sure if that's through not wanting to know or just a lack in their training. What are your thoughts? That is,
I would say both, because firstly there's no mediation training that is compulsory in terms of our law degrees. So ADR is not compulsory for you to learn about, which means it becomes an elective, which they think it's more like therapy. They don't need to deal with this. That's the psychologists and social science Bachelor of Arts students deal with it. But in our law, it's not pushed as you must learn negotiation skills, you must learn mediation skills. So we then have these graduates coming out only knowing the traditional approach of litigation. Yes. It's going to be, it is being rolled out in some of our universities in South Africa as adjunct programs or diploma programs, and there are those who come in for the training, and then when I see them for the training, they just want you to hurry it up. Like, can you just tell it to us in a day? And it's actually not that, because it's a skill. So it's a skill set. It's not an understanding of the theory. It's the only way to learn it is to practice it. So you've got to give your full focus and time to sit there, do the role plays, understand. And it's only when, and it's usually the first step that go up to role play that mediation, realize I need to keep quiet and pay attention to the rest of these lectures and this program and stop fighting it. So
they realise they're not that great at the role play, and what was that again? What do I do? Yeah. How do I make
why? And most of them just walk out sweating, and so the second part is there are so many that are reluctant to even learn about it. They or don't want to at all. They go, this battle approach works for me, I'm good at it, I don't need to know. So the misconception of mediation then comes out, because they then send clients to do the tick box approach. And when I know in my offices, when we get the call, the attorney will call to say, well, what issues is the mediator going to be dealing with? Because we're dealing with the assets and we're dealing with maintenance or the budgetary constraints. The mediator must only make a decision on the parenting plan. And so we have to inform them that, well, no, actually the mediator doesn't make any decisions. It's the party that makes the decision.
Yeah.
So it's also that lack of knowledge of what mediation actually is.
Yeah, absolutely. And that's, that definitely comes through in that sort of language where they think that, they think we're an arbitrator. They don't know the difference between mediation and arbitration.
Yes.
Yeah, which is pretty sad. I think surely that could be in the compulsory part of the law degree.
You would at least spend a day just explaining the differences and just understanding that mediation is ancillary to the legal process. It's not taking away from the legal process, because at the end of the day, the parties still need to get that agreement made at court order. So we're not taking anything away from you.
Oh, well, we are taking away, if you know, the difference between writing up orders and having a full contested case. There's certainly a big financial difference in what they're getting there. There is a tension, but I'm finding here in Australia that a lot of lawyers, particularly female, but not exclusively, are moving full time into mediation now. And collaborative practice. Is there much happening in collaborative family law over there at the moment, or have you come across that?
There are rumbles that the collaborative approach is more advisable for especially family disputes. And yes, there is a lot of buy-in from female lawyers.
Yeah.
And I think it's because of the communication way that a female has in terms of being more collaborative with their peers, as opposed to wanting to have the upper hand in these discussions. So there are very small steps being taken towards the collaborative approach. Well, that's what I find in my classes, because I'm always grateful that there are majority of them are men in my training sessions, and they really give it their all. They, you know, as females, because females have, not all, but some of them have that very gentle approach, and they sort of deal with the disputing parties like they're dealing with children. So you know, they have already that maternal way of just separating fighting siblings. So. And the males, and that's why I really admire what they do, is because they make a concerted effort to have that nurturing, concerned way of understanding what the conflict is about. You know, like I said, after that first day, after that first mediation role play, which I usually give to the males, they understand, no, it's not what I thought it was. And it really isn't therapy either. No. So I'm not steering away from what I initially trained to do. I'm actually using my skills differently, or I'm separating my personality, so to speak, from being someone who sees things from one angle and someone who sees things from all sides.
Yeah, absolutely. And look, certainly the lawyers that I've trained indicate that learning the mediation skills definitely enhances their skills right around in their legal practice. So, you know, it helps with their court work because they've got better perspective on what's going on. And of course, there's many little negotiations you need to do with your own client as a lawyer as you're going through the process.
And I think it's very important that negotiation skills get taught as well, because mediation is facilitated negotiations. And the negotiation component of it, if you don't know where the parties are in terms of that negotiation, you actually don't know how to move them forward. So you're unable to identify if an offer actually has been made, or there's a step in the right direction, if you yourself, your negotiation skills are lacking.
Yeah, so absolutely. Yes, I've seen many a new mediator that walks all right over the top of an agreement that's starting to form. And
and yes, and I guess a lawyer creates a realistic agreement that has to be carried out. But if you haven't negotiated the finer details, that agreement means nothing. It can't be carried out.
No, that's right. And that, so that reality testing and what would, and you know, if we can break the agreement in the mediation session, you really didn't have an agreement. So it's much better that we really test it out in that environment where people are at their most willing to try and get a resolution. And generally, if you do that, because one of the things I often notice is that people, you know, if they see an agreement, they latch onto it and, do you want me to write that up? And then, you know, okay, that one's sorted, without really testing how's that going to work, and what happens if what you're proposing can't happen, what will you do instead? How, you know, getting that, I suppose, you know, testing it out a little bit.
And that's something that I think one of the tools that mediators have in their little box of tricks is reality testing, because legal practitioners don't send their clients out to say, go check if it works.
No.
A mediator does that. And like I said before, when they come into their first mediation session and the clients are throwing things at you, I want this and I want that. And your one question is, well, okay, go make it work and tell me what it looks like when you implement it. And then come back in your next mediation and tell me, did it work? Because you're not saying no, you're saying, well, does it work? And then they come back a little more informed that, well, we were just, pulling things out of the sky and just being unrealistic. And that reality testing component is very diminished when they're so locked into battle. And when I train legal practitioners, and even if they go back and not mediate, they use that reality testing component when dealing with their clients to say, well, actually, no, you cannot get that.
Yes, absolutely. Because, and if they help their clients to think through things like that, there's more likely that maybe they'll get a resolution through lawyer negotiation or earlier in the court process, and they won't become so entrenched with that, belief about some entitlement that just isn't going to happen, in any shape or form. No. So what made you change from, from just being a legal practitioner to mediation? How long? Where did you how did you train in the beginning?
It was being a litigator. It was from being a litigator, standing outside court. I remember discussing, it was around 2003, discussing a matter and just looking to the side. And I saw a woman and her children sitting on the stairs of the court and just looking destitute and had no help, had no legal information, just waiting to get divorced. And her husband walks past with a team of lawyers. They go in, and I'm listening to the discussion she's having with a person on I think it was a counsel that walked past. She's trying to ask him a question, and he's not interested in answering the question. He's just walking past. I jumped in there and said, "Look, we've got to find you an attorney that can can do a bit of pro bono work for you, just to get you on the right track, and I will then step in and take over from the attorney or represent you." And it was then that I realized that too many people have no information on legal processes. And it is too daunting, too intimidating to be in a courtroom. You've got young children, you only want the best for them, but you don't know how to get it. You have no funds, you have no time, you're probably actually using up your time from work, which you're not going to get paid for, waiting on the court steps. So the mediation, I started to research about a better approach, different methods of having people have access to legal processes, and mediation fell into my lap. Fortunately, we have good training institutes in the country that will put you on the right path of learning what it's like to be a competent mediator. And so around 2004, I decided this is the path, and following year, this is the path I'm going to take. And just spent years and years learning, getting accredited for it, getting internationally accredited for it, and practicing it. The only way to actually understand that this is the way to go is if you practice it, when you actually see it for real. So, I then started through fair practice, started doing more work on legally informing people about the mediation process.
Yeah, and that's it's such a critical thing in informing people about mediation and the court system and the whole either family law system or fair work system or whatever area that they're in. It's I find it's very, very difficult for people to reach agreement if they're completely confused about the system that they're in, because they don't know what's a reasonable thing.
It is, and the power imbalance comes to play. So it just, and I'm not saying I'm focusing on women, because you can't take a hard-headed approach to say I only focus on the women. It's just to say, bring both people in the room so they can hear each other, and at least the one with the less power gets an equal footing in the process itself to have their voice heard. Because in any other forum, they wouldn't have their voice heard because they don't have the resources to do that. No. And if a mediator must take the approach to hear both sides, that person finally gets that opportunity to say what they want to say. And of course, there's a lot of emotions and fear and anxiety and tension, but it's a start to actually asking for what you want.
Yeah, absolutely. And, it's a step away from that adversarial process where people are dehumanized. And I think sometimes people forget that this is actually their partner or their employer or workmate or whatever, and they just become this monster that they've got to fight. Does that?
It does. It brings out the worst in people.
Yeah, it does. So getting them there talking, actually hearing the distress that the other person's going through, sometimes it can build back empathy. And, we know that empathy is such a critical component of interpersonal, collaboration. Without empathy, it's very difficult to, for people to move forward out of their positions.
It is, and with that empathy, you would find that they remember, like you said, they would remember a moment that they were together, and then start to see each other as people working towards preserving a relationship for the sake of their children. Yeah. And in terms of a family or a divorce mediation, and you bring that focus back to them, because the objective criteria in this mediation are your children's interests. Yeah. So they tend to then focus on that, and then the communication changes in the room. There's not that much antagonistic manners towards behavior towards each other. So it doesn't, they're not seated across the table from each other in most instances, where someone else is speaking for them, who really has no idea what their personal circumstances are or what that family really requires at the end.
Yeah, look, absolutely, and it's really great, isn't it, when you get that shift and they start working on kind of problem solving and, how we're going to work this out, rather than, you're doing this to me type attitude.
Yes.
Yeah. So, okay. Well, look, this is wonderful. I'm just wondering, you've been in practice for quite a long while, and you're training mediators. Is there any advice that you really like to give to people coming into the industry? Anything that you think they really need to know?
I think they would need to focus on themselves. Yeah. They would need to understand their triggers, their perceptions, their bias, their tendencies to assume too much. When you're coming into this industry, you do a lot of introspective learning, a lot of interpersonal conflict of your own needs to be handled, because you cannot have triggers going into mediation. You must be able to understand your own triggers, be able to deal with your own triggers and your emotions. So the confidence of a mediator comes from understanding yourself. Yeah. If you're reluctant when you walk into the room about what if it's a matter that's close to my heart or close to home, you must be able to make the call to say, I'm going to actually be biased, or I'm not going to be impartial in this matter, and walk away from it. That ability to understand yourself is what makes mediators successful, and it makes people want to work with them, because again, like I started saying, the mediation is not about you. So the one thing that mediators must use as a tool to focus, do that interpersonal focus, is the communication skills they use when dealing with their clients in front of them. What are the words that they're using? What is the tone that they're using? What is their attitude in the room? How focused are they to perform fairly? I know I call my organization Fair Practice, and a lot of people misinterpret that the outcome of mediation is going to be fair, which it isn't. It is fair practice is how do you as a mediator practice fairness, and that is why the mediator skills. You can't stop learning. You can't stop improving your skills. You can't say, I did, in our country, we do a minimum 40-hour training program and say, that's it. I'm a fully fledged mediator. I know what's happening. I'm the best. I'm the expert. There are people who come into training and they do have the personality to be a mediator, but you've got to constantly learn about yourself. You've got to constantly take personality tests that are online to understand where you are in your moment in your life to say, I can handle a mediation.
That's very, very good advice, because it does vary. You know, the things that are going on in our own lives can easily trigger or have us not in the right mindset being in that role, because it is a demanding role to be that, you know, that impartial person. You know, we need to know when to walk away or when to step away if necessary, if we're associating too closely with someone or feeling too repelled by them or whatever.
Yes, because I think at the end of the day, if someone turns around and says, my mediator was biased, and you want to defend that, you actually have to take a step back and say, well, was I really? I could have been, because I remember something that was said triggered something in me, and maybe my tone or the words I used or the way I interrogated that person, not actually asked them questions of clarity, but I interrogated that person, could show that I was being biased.
Yeah. The challenge we have as mediators is that much of our work is done in private, with no one there able to, give us the feedback. Clients don't really know what to expect. They, whatever we do, unless it's really out of the range, we're not really getting the feedback from them. So we have to do the self-reflection. We have to have practice groups or colleagues that we can talk with. Have you got any, what do you do in terms of that type of reflective practice?
Before I go into a mediation, so I start there. Before I go into mediation, I always work, and no matter how many times you do a mediation, you always do this. You take a moment for yourself and you work out what you're going to say in your opening statement to the clients, or your introduction. Yeah. You have to understand that as many times as you have done this is their first time sitting in a mediation. Yeah. So you have to go through the whole focus on your duties, your functions, your role, the rules of engagement, understanding what the process is, understanding that the outcome lies in their hands, but the control of the process lies in yours, that you're here to facilitate but not to make a judgment. You need to understand that as a mediator, when you're starting out practicing, as nervous as you are in that first time or every single time, because you don't know what to expect every time a set of clients come in, is take time out, take at least 10 minutes, if you can, to talk to them about who you are, your function, understanding your impartiality, giving them that, building up and giving them that trust they should have in you, that you're going to be impartial and unbiased, that you're going to remain as neutral as you possibly can, and that you will tell them that this is how we're going to run the process. So you also throw to them that there are times when we might need to take a break because we've been in this mediation for too long. Because that in yourself is when you're telling this to the clients, you remind yourself that if I've had enough, or if I need to take an emotional or mental break from what I'm listening to right now, I've already forewarned the clients that we may be taking breaks in between, because that's your inner check to say, I'm actually getting drained from listening to this, or I need a moment to process what I've just heard. And so, that's how you can take your emotional break from what is happening in front of you, especially if you're dealing with divorce and mediation. Things can go awry and it can get tense and highly emotional. So you remind them that we're going to be taking breaks now again. With regard to having peer assistance, or I am very fortunate to still have my mentors available to me should I be in a situation where I'm uncertain what I should do, what the next step should be in terms of, well, when it comes to actually chairing hearings or just trying to weigh out factors where I have to make a decision on a finding or given a penalty. I do have my mentors from that facet where I can say that this is what I'm struggling with in terms of weighing these factors. But mediation is an isolated process, and it is an isolated profession because of confidentiality. So we really can't go around talking much about what is going on in terms of our clients' disputes.
No, certainly not the detail or anything that would indicate, who the clients are, or we can't be having little salacious chats about it. But certainly under our standards here, we're able to participate in supervision or peer support type practices as long as we're not identifying the clients. And you don't need to. It's really about the types of issues, isn't it?
It is, and with Australia having more than 20 years of mediation in the legal system, we're South Africa looking towards Australia and wondering, moving in the direction of bringing in your practices and bringing in how you're moving forward with it as guidance to how we should be implementing your procedures and regulations and practices, and fitting it into our communities. And well, we've always had mediation since the start of African culture, because Ubuntu is the way disputes are resolved in African cultures and African disputes. Yeah. So there's always that reconciliation methods, there's always that focus on the relationship, and a community-based outcome for disputes that happen within the African cultures, African communities.
So it's really a bit of, in some ways, rolling back the European overlay that's sort of come, and in some ways similar here in Australia. Many of our Indigenous communities are really in quite a terrible state because of the colonisation, but their tradition was certainly that they had very, very strong mechanisms for resolving conflict and disputes through discussion and through processes that they had. So it's an interesting, in some ways, a revolution of a wheel.
Yes.
But taking the best of what.
Well, it's going full circle.
Yeah, it seems to be, which is, I think, a good thing. I'm just mindful of the time, and I've really, really enjoyed having this chat. Just one thing. One of the areas that we're working a lot with is with video mediation, and which is completely opposite end of the spectrum from the traditional, I suppose. Is there anything much happening in South Africa with video mediation? Do you know? Or?
There are discussions. There's a research going on online mediation practices. It can be used. It is open for people to use, especially when we're dealing with international companies or in corporate. We're dealing with clients that are internationally based. So it is not ruled out. It is there if anyone should need it. So the mediation can be done online.
Yeah, yeah,
We're
absolutely.
not it's not regulated, but
Yeah.
it can be done online.
Yeah, so probably in the early days, well, I mean, it's still constrained by, how good people's internet is and all of that as well. So,
Yes.
yeah. So, are there any final thoughts that you'd like to share before we do sign off?
Well, thank you for this opportunity to be a part of your discussions. And we are looking to Australia for guidance on mediation, the practices. A lot of discussions are still coming out in terms of child-inclusive mediation that's coming out of your researchers in Australia. We really want to also get it right. We want to get the practices right, and I think mistakes that we make in following through really is about it's just a learning curve for everyone. We don't have all the answers right now, and we just want to do it in the best interest of everybody.
Yeah, oh look, absolutely, and we don't have all of the answers in Australia either, so we're still very much on the journey, but it is absolutely a great idea to try and learn what's working in other areas and not. With what we're doing with Mediation Institute is we're exploring with a couple of different approaches. One is family group conferencing, which we've just introduced training for that, and that's in Australia. It's mainly used in the sort of child protection area where things have got really bad. But
we do have that as well in our Child Justice Act, where we talk about family group conferencing as well.
Yeah, which has come out of New Zealand. But we're really looking at how can we use it in families that aren't at that level, that just with normal family breakups, where we can use that to bring the child into the mediation rather than bring the child's voice in. But the other is the child inclusive practice, where the child meets with either the mediator or a specialist, and then they bring the not what the child wants, but what's going on for the child back into the mediation. So, look, if there's any any information or resources that we have here that I could certainly connect you with without any difficulties, or others that are looking for that. So, perhaps afterwards. If you do want any connection.
Thank you. Yes, thank you.
It's
thank you.
Yeah, because look, it's really important, because I share your concern that children do tend to get sidelined, and that actually can be quite detrimental to them when these life-changing decisions are being made without them having any involvement at all. We could do better.
Yeah, I think, and as it is, our learning is also evolving. So we're going to be going through a lot in the next how many years? We might not get it right, but at least we're moving in the right direction.
Oh, absolutely. And we've just had a very major review of our family law system, and we don't know what's going to be adopted. So, in probably won't be 6 months or more until we know what changes are going to be actually proposed to incorporate into our next upgrade of our Family Law Act. So there's lots and lots of change. But the focus is, as you're saying, very much more on how do we involve children more into the process, how do we make it more appropriate for them, and how do we keep costs down and get people to family dispute resolution, particularly in the family area. So there's certainly looks like there's going to be more focus on using mediation for property as well as parenting, which I think will be a really good thing, although they've stopped short of recommending that it's mandatory. So we'll see what happens. I'll keep you updated.
Thank you very much.
No, well, thank you so much for your time. It's been a real pleasure chatting with you.
I'm appreciative and grateful that you've given me this opportunity to voice my thoughts. I think we get so involved in everything that we don't get to actually have a conversation with a fellow mediator about what it is that we're doing. And it's really an honor to be speaking to someone internationally. So thank you very much.
Oh, you're very welcome, and I feel exactly the same. I've been having so much fun with this